And we're recording. Go right
Cool.
ahead, address the call.
Okay. Hello, everybody. This is Eric Lindell Moore. As all of you know, I'm not an attorney. I'm not a financial advisor. I'm not a broker. I'm not a broker dealer. I'm just a value investor. And this presentation is not an offer to solicit you to buy, sell, or hold any security, be it Sears Holdings, be it JC Penney, be it NVIDIA, be it Mr. Cooper, SRG, Lands End, AutoNation, or any other stock, bond, or security. If you're interested in buying or selling or holding a security, you can contact your own CPA, financial advisor, um, broker dealer, etc. Again, this is not a solicitation for an investment in any stock, security, or bond, and it's not a suggestion for you to hold that stock, sell that stock, or buy that stock or that bond. I'm going to share my research with you and share with you what I'm doing with Sears Holdings and get everybody an update on what's going on with the Sears Holdings and Transform asset sales, real estate sales. I'm going to walk everybody through uh, the financials and the numbers, and hopefully I can make this as short as possible and clear as possible. Shouldn't be more than 15 minutes. And I'm going to walk everybody through um, the beginning of the bankruptcy. It's going to be very quick, and these materials will be available on the screen for you. And most of this information, if not all of it, you'll be able to click on this particular chart and read it for yourself. So I'm going to explain to everyone why this was missed. And I think the $1,000,000 question, it's only several questions I get. It's, quote, why is it taking so long? Number two, why did everybody else miss this opportunity? Number three, did I lose my money? Number four, where's my stock? I don't think I see it. Number five, why does one day it say my bonds are worth 20 million and the next day it says they're worth $20? So a lot of those questions. Most of the questions I can answer, most of them I cannot. All right, so in most bankruptcy cases, there is no unencumbered collateral to speak of. Because generally speaking, when an entity, whether it's an individual, whether it's a small corporation or a large corporation like Sears Holdings, when they go into bankruptcy, they generally borrowed against most of their assets. The same way if an individual person in bankruptcy goes into bankruptcy, generally speaking, that person has borrowed an entire, they probably have maxed out their credit card. They might have a car get ready to get in repo. They may have a home that's about to be foreclosed. But generally speaking, they don't have unencumbered collateral or available cash to use to pay their debts. Generally speaking, that's the challenge. Or you can have assets that are valuable, they're just not liquid at the time, or they're illiquid. I was in General Growth Properties bankruptcy around 2008, 2009 during the financial crisis. They owned about 400 shopping malls, including Four Seasons Mall in Greensboro, North Carolina, not too far from where I grew up. And they also owned, if I'm not mistaken, South Point Mall in Durham. But they own 400 malls across the country. And Bear Stearns and or Lehman Brothers and or one of the other banks that failed were their actual lenders. And they had, so long story short, they had a very difficult time trying to refinance their debt that happened to come due during the financial crisis. So they had plenty of assets, lots of free cash flow, 400 million in cash, but because of the financial crisis that was going on, they didn't have the money to actually pay their debts off. So in the General Growth Properties bankruptcy, there was a covenant in the loan documents that said that they cannot renegotiate those loans or the maturity on those loans unless they were in bankruptcy. So they filed bankruptcy in order not to violate those covenants and to raise a little bit of cash. And everybody knows how that bankruptcy worked out. The stock went down to 25 cents from about $40. Bill Ackman of Pershing Square and Bruce Berkowitz who was a large investor in Sears, of Fair Home Capital and Fair Home Funds, they got together. Bill Ackman bought the stock. Bruce Berkowitz bought the bonds, recapitalized the company. They renegotiated the loans, and the payout was somewhere between $35 and $40. I bought most of my stock around 75 cents. And it was such an incredible opportunity. I prayed that if I ever found another opportunity that lasted long enough for me to tell or at least inform my close friends and family, I would. When you make 30 to 50 times your money on something, but it happens really quick, like in a couple of months' time period when the stock blew up, you don't have time to call around and tell people you have a great opportunity. And unfortunately, you also don't have the time to explain it to them. So they think you're giving them a stock tip and you're giving them something that has mathematical certainty. So what I like to focus on is mathematical certainty, not what a bankruptcy judge is going to say, not what people on Seeking Alpha, Stock Twits, and Reddit are saying, but what I call mathematical certainty. So we're going to go to slide 1, and I'm going to talk to you about Sears Holdings, and I'll walk you guys through the process really quickly. Slide 1 is a transcript of the day Transform bought the assets out of Sears Holdings. And slide 1 was filed on February 11th, 2019. And Adrian's going to pull it up for you in a second. So in a bankruptcy, if you have unencumbered assets, you have to explain to unsecured creditors, the stockholders, you have to explain to them what is going to become of the unencumbered assets. Unencumbered assets mean they have no lien, no mortgage, and generally no debt on them. So these assets are not encumbered by mortgage or lien. So it's the same as having a home that's completely paid off without a mortgage. That's what unencumbered means. Believe it or not, we have MDs, we have PhDs, CPAs, JDs, and a lot of people were unfamiliar with what an unencumbered asset was. So in this particular bankruptcy, and you'll be able to click on the chart that Adrian's going to show you later, and I'll walk you through it. The unencumbered assets was a long list of real estate, which I'm going to show you, but I'm going to show you the proof. And everything I'm going to walk you through, I'm going to show you the proof. All you'll have to do is come back to this video if somebody tells you there weren't any unencumbered assets. You might call an attorney working the Sears bankruptcy. You might call the wind down, and they might tell you there weren't any unencumbered assets. And you're supposed to say, well, tell me why they said there were on February 11, 2019. Can you show me what happened to the unencumbered assets? Because the day of the sale was February 11, 2019. So let me read you what the court said. The judge said, is there a value here in the unencumbered assets on a reasonable basis in excess of either 3.9 billion or 3.5 billion, depending upon how you count the rollover of the the junior dip? The answer was, I think there is, Your Honor. And he goes on to explain about the unencumbered assets. So the junior dip debt, and you can write this down if you like, was only $350 million. If you go to document 892, they will show you that the junior dip debt was only $350 million. So we're going to round this 3.9 billion number to 4 billion. And we're going to deduct the $350 million, and I'm going to show you when it was paid. So if we deduct $350 million from $4 billion, we have roughly $3.75 billion in unencumbered assets. And they said at least that much or in excess of that much. But let's just go with the low number, 3.75 billion in unencumbered assets. Everybody here on the Zoom understand what unencumbered means. Anybody got any questions about unencumbered before I go further? If so, raise your hand. Everybody's clear that an unencumbered asset does not have an ESL or an Eddie Lampert lien on it. Is everybody clear on that? All right. So let's track these unencumbered assets. Okay, somebody got a question on it? Jason, go ahead. Or Blair, go ahead. Let him get in.
Hey, Eric, this is Jason. So this here says that it's unencumbered assets in excess of the 3.5 billion. So if there
That's
was 3.4 billion of encumbered, this Mr. Qureshi would still be correct to say that there's 100 million over the 3.5 billion or whatever that is, right? Am I reading that correctly?
Yeah, he's saying the judge is asking him, is it more than 3.9 or 3.5, depending upon how we count the junior debt? And they say, I think it is, Your Honor.
Okay, but it could just be barely over, right? Not.
Yeah, it could be barely over. Sure.
Okay. Good
Sure.
deal. Yeah, that was all my question. That was my question.
Okay, no problem,
Thank you.
Jason.
Yeah,
Okay,
thank you.
so let's take the $4 billion, deduct the $350 million from the junior debt, and I'm going to show you what page. So on page, this is where you can see the amount the junior debt was if you want to look it up, and I'll show you later. It's document 3276, page 41, and it's listed 15, 20, 30, 40 other places. Document 3276, page 41. That's the plan document. It shows you that the debt was only $350 million. Okay, so $4 billion minus $350 million gets us to $3,750,000,000. This is unencumbered. All right. So we're going to go to the second slide. This is document 892, page 15. This is inter-creditor agreement. And notice the date is November 27, 2018, roughly 30 days after we filed bankruptcy. And I'm going to show you the definition of what pre-petition unencumbered collateral is. And I'm going to show you why I'm so sure about the math in Sears Hold'em. Going to walk
Eric?
everybody through this. Yes, Adrian.
I don't know if everybody else can hear it, but your phone was breaking up pretty badly on my side. I'm not sure if something's changed.
Okay, so I'm going to repeat that. So I'm going to walk everybody through. Can everybody hear me clear? Look, everybody. All right. So I'm going to walk everybody through what definition pre-petition unencumbered collateral is, because they define what that collateral is in this inter-creditor agreement. This is document 892. An inter-creditor agreement is an agreement between more than one creditor. And creditors may have liens on the same property. And once lien number one gets paid, lien number two gets paid. Once lien number two gets paid, the third lien holder gets paid. But if there's anything left or unencumbered, they have to explain who gets the unencumbered assets in the event of a sale, in the event of a credit bid, in the event of a Chapter 7 instead of a Chapter 11. All right? Everybody clear on that? So they define what is unencumbered, so none of the people with liens make a claim to this property. So pre-petition unencumbered collateral in the Sears bankruptcy says shall have the meaning set forth in the financing orders, provided, however, that the term pre-petition unencumbered collateral shall not include the specified collateral. Provided further, however, the term pre-petition unencumbered collateral shall include the assets set forth on Schedule 3 here too. So Schedule 3 on document 892 is attached. So I want everybody to remember the term specified collateral, because they're making it clear that the specified collateral is separate from the pre-petition unencumbered collateral. That's another set of collateral that we'll go over in a second. So we're going to turn to Schedule 3 to see what our unencumbered collateral is. So in document 892, the next slide Adrian's going to pull up is Schedule number 3. Everybody with me so far? All right, so keep in mind, all right, this is page 54 of document 892. And they list what is deemed unencumbered collateral. In the first paragraph, they're talking about some bonds or some notes that were sold. That was unencumbered. That brought in, I think, about $80 million. Then they list Sears Home Improvement products and a couple of the smaller businesses that they sold. And at the very end, on page 55, at the bottom, there you go, thank you, Adrian, scroll it up. It says, to the extent not otherwise covered, all other assets and all other proceeds of any additional assets of the obligers, in each case to the extent not constituting pre-petition ABL collateral and not otherwise subject to a valid and perfected lien or security interest as of the petition date. In a nutshell, without getting deep dive, it's deemed unencumbered unless it has a lien on it. Everybody clear on that? So this, I know this is legal mumbo jumbo to some of you, but I want to make sure everybody is clear. They know how these assets got where they got and who they belong to. All right. So now we're going to go to the next slide, and we're going to see what this document says is going to happen if any of the unencumbered collateral is sold. So document 892, page 39 is what's coming up next. And this is the same document. This is not the bankruptcy plan. This is a document that was signed by the secured creditors and the unencumbered creditors and the unsecured creditors committee roughly a month after the bankruptcy. Notice at the top it says Doc 892, filed November 27, 2018. So what happens to these unencumbered assets if they are sold? Remember, they don't have liens on. The people with the liens on on the other collateral is Eddie Lampert of ESL and Cyrus, who also has the junior dip. Those are the two major lien holders, and they're also the bondholders, the secured bondholders, which was the second lien bondholders. Okay, it says section 6.4, asset sales. If you go to the highlighted portion, which is what we're going to skip to, actually, I'm going to go right before that. It says the junior dip agent agrees. So the junior dip agent is the person in charge of making sure the $350 million that they're owed gets paid. Okay? So they have an agent, so like a trustee or a bank person or a manager that's in charge of that collateral and that money. It says the junior dip agent agrees on behalf of itself and the junior dip secured parties that it will not oppose any sale or bidding procedures consented to by the senior dip agents. There was a senior dip loan that was above the junior dip loan. And they say by the senior dip agents of any collateral other than the specified collateral at any junior dip collateral constituting pre-petition unencumbered collateral pursuant to section 363F. So let me stop there. 363 is the bankruptcy code that they use generally purchase assets out of a bankruptcy or to credit bid assets out of a bankruptcy. So if you sell assets or you purchase assets that are unencumbered, you can take them out of bankruptcy under various conditions. You either have to pay people cash on the spot the day of the sale and say, here's your money for the unencumbered collateral, which didn't happen in this case. Or you have to promise them that when you sell the asset that does not belong to you, that the liens of those parties will attach to the proceeds of the sale. So if you take this house out of bankruptcy and you sell it and you generate $4 million, the $4 million in cash is what your lien will be on. So your lien attaches to the cash because they sold the house, but they've been given permission by the court to sell it under the condition that you get your lien on the cash. So let me finish reading it. It says, so long as the liens of the parties attached to the proceeds of such sale consistent with the lien priority set forth herein on the assets sold, and such proceeds and otherwise are applied in accordance with this agreement and the financing orders. If some time, take a look at page 20, Doc 92, page 20, and they show you the lien priority. But for time, we're going to go to the next slide. So we automatically know that if we sell any of this unencumbered collateral, If it's an asset sale, liens of the parties will attach to the money. All right, we're going to go to the next slide. And this slide is document 892, page 41. And I'm just going to pull it up in a second. And in this particular side, under section 6.9, what if somebody credit bids for these assets? And everybody knows what a credit bid is. If you owe money in a bankruptcy, you don't have to bring cash. If you have $1 million lien on a $6 million house and the house goes up for auction, you can say, I hereby bid my lien. Credit bid my lien. I'm not giving you another $1 million. I already gave you $1 million and I have a lien on that property. So I'm going to bid my credit. That's why it's called a credit bid. In this case, as you can see, section 6.9, they're trying to explain what's going to happen to the specified collateral and the unencumbered collateral in the event there is a credit bid for these assets later on in the bankruptcy. Yes, go ahead. Everybody can hear me? Okay. So here you can.
Yes.
Okay, you can hear me. Okay, everybody with me so far? Is it too complex? Do I need to break it down more? Somebody talk to me.
It sounds good. You're making
Okay.
it plain. You're making it very plain.
All right. Thank you. All right. So what we're doing with these assets that we know are worth more than $3.75 billion or at least $3.75 billion, we know they don't have any liens on them. So if somebody comes to buy the company in whole and they want these unencumbered assets, how are we going to take care of the people we owe with these unencumbered assets? Because the person credit bidding doesn't have a lien on it, because you can only credit bid if you have a lien. The same way your mortgage company cannot foreclose on you if you don't have a mortgage. If you pay off your house tonight, they can't show up next week and say, we want the house. But if you owe them $1,000 and it's $1 million house, they could foreclose on your house and they might sell that house for $1 million. And they don't keep the $1 million. They pay themselves $1,000, and the other $1 million, the $999,000 or whatever, $999 or $90 would go to the homeowner. Everybody knows that, right? In a foreclosure, all surplus goes to the homeowner. Is that clear to everybody here on the call? Somebody talk to me.
Yes, sir.
All right. If they take your car and repossess it, and you owe them $7,000, and they sell it for $40,000, the remaining money does not go to the people who financed your car. The surplus money goes to the car owner. Everybody here understands that, right? All right. So in this situation, everything that you can do in a foreclosure with a car, a repossession with a car, and a foreclosure with a house, everything applies the same with a corporation. In this case, Eddie Lampert did the equivalent of a foreclosure of the Sears Holdings assets that he had liens on. He made an arrangement in document 892 that anything that's surplus will go to everyone else and not just to me. So in document 892, he said, if we credit bid, here's what it says. When calculating the amount of the senior debt obligations, that's another debt that was above. It was roughly $1 billion or so. So let me read it again. In calculating the amount of senior debt obligations comprising any such credit bid, the value of the specified collateral and the junior debt collateral consisting of pre-petition unencumbered collateral shall be disregarded. And the liens securing the senior debt obligations and the junior debt obligations pursuant to the financing orders on specified collateral and the junior debt collateral consisting of pre-petition unencumbered collateral shall not be discharged in connection therewith. So they're saying that the liens are going to stay on there even if we credit bid. The liens aren't being discharged because we haven't been paid yet. So our liens are going to carry on to whoever buys this property. The same way the mortgage company's lien does not come off the house if you quit claim it. You can't quit claim a deed and say the mortgage is gone. It's my house now. So this is exactly the same process on a multi-billion-dollar scale with a corporation. So what happened to this collateral? Because Eddie Lampert did do a credit bid and he did do the asset sales. So let's find out what happened to this $3.75 billion and see who is entitled to it. So what Adrian's going to pull up right now is Exhibit 10.4, which was filed in 2018. This was filed on December the 3rd, 2018. This is the same intercreditor agreement. They have something called the specified collateral. So it's two types of collateral in this case that are unencumbered. It's this, well, some are encumbered, but it's the specified collateral and the unencumbered collateral. So what Adrian's going to show you is what the specified collateral consisted of, and I'm going to show you where our money is. And this is from December 2018. This is not the bankruptcy plan. This is not the sale. This is before all of this happened. So the example I gave on StockTwits is, this is a prenuptial agreement. This document, 892, the intercredit agreement, is explaining what is going to happen to these assets in various situations. The same way a prenuptial agreement says, if Blair gets divorced from Jennifer Lopez, or Raul gets divorced from Keith, how much money you're going to get. Here's how many cars you get. Here's what you get to keep. Here's what I get. So this is happening before marriage. A prenuptial agreement happens pre-marriage. An intercredit agreement happens pre-bankruptcy plan. Everybody online is focused on what the bankruptcy plan is saying, and I want to focus you on what they agreed to before the plan was consummated. Everybody's clear that we are not in the bankruptcy plan. We're in the prenuptial, so to speak. Everybody's clear on that.
Yes, thank you. Eric, can you guide me as to exactly which schedule I'm to pull up for this portion?
Okay, you're going to go to Exhibit 10.4, and you're going to scroll to 1.07.
The initial specified store closing locations? Got it.
Yes. So all this is publicly available. It's been publicly available the entire time. The challenge is the complexity of not understanding how bankruptcy works. Makes it easy. And when you see and you hear about Sears Holdings, you hear about all the stores closing, most people don't read. They just assume the company is completely bust. There's no valuable assets to be had, so on and so forth. And that's generally what the press was saying. The retail division was having some challenges, but as you know, Sears Holdings has more than just a retail division. Okay, this is Exhibit 10.4, and this is a list of the stores that they were closing. Hold on. Before you roll it, let me read the top, what it says. At the top, it says initial specified store closing location. Everybody remember the word specified. So these are the stores that were closing, and Adrian's going to scroll it. These stores have $5 million of inventory, generally speaking, in each one of them. 687 total stores at the time of the bankruptcy. This is the list. Part of the list. So for the purpose of the video and the purpose of time, you'll be able to click on the exhibit and you'll be able to see the initial stores and what they call the secondary stores and what they call the going forward stores. Roughly 425 stores went forward over to Transform. They liquidated all of the stores as of today. There was one store remaining, and I think after the Christmas season, I think everything's been liquidated out of that last store, that last Kmart that was in the Hamptons. So let's find out what happened to these assets, because we know these assets were bought by Transform. Everybody knows that, correct? Transform got these assets, and they also got a list of real estate. So we're going to go back to document 892 and take a look at how many real estate properties were unencumbered. So we're going to go to document 892, Adrian, when you get a second, and we're going to pull up right under Schedule 3 and show them the list of real estate properties that had no mortgages and no liens on them when you get a second. So while she's pulling that up, we had roughly 1,100 pieces of real estate with no liens, no mortgages, and no encumbrances. We had roughly 8,000 acres of land in mall real estate, in mall parking lots mainly, and we had roughly 8 to 10 acres of land in each location. And this is listed in document 892, the same document we've been going over the whole time. All you have to do is pull up Schedule 3, and you're going to see that all of this real estate was unencumbered.
So this is this the 3.65 billion unencumbered assets?
Yes, this is the yes, this is at least that amount. Yes, it is. Yes,
Okay.
it is.
So the question is, basically your unencumbered assets, if I might ask a question, are essentially these locations, the real estate, the store, the mall space, and maybe some of the inventory that was liquidated. Is that correct?
Yes, and also Innovel Solutions, Die Hard, Kenmore, Sears Home Services, the Shop Your Way credit card. Yes, all unencumbered.
And so I guess the question that I have is, and I understand all of this, these assets are sitting there somewhere. They're just sitting there. And they've been sitting there since 2018, 2019. This is 5-6 years now.
No,
Okay.
they're not sitting. They're not sitting. They're at Transform.
Okay. And so if you hold shares of Sears here, and you are a creditor against the unencumbered assets. Is that correct?
Yes.
Okay. And so if these are now at Transform, that these are the unencumbered assets at Transform, why do we not have shares yet of Transform?
I'll get you there, Manoj. I'll get you there. I just recognized who you were. How you doing? I'll get you there. Give me a second. I'm good. I'm good. I just recognized you. Okay, I'm on the way there. Give me a few more
I'm just
minutes.
sitting here at home, but you go after work and laying in bed watching TV.
I'm shaking off a cold.
It's Christmas Eve. We're not doing anything until tomorrow.
That's right. That's right. And it's dead where me and you are right now anyway. So it'll be jumping tomorrow night.
Yes.
Okay. So I'll keep going. I'll get you there. Okay. So you're correct, Manoj, in exactly those assets and where they are. So this is Schedule 3, the unencumbered collateral. And if Adrian will scroll for me, she's going to show you how long this list is.
Because the other issue, and I'll say one more thing.
No, go ahead. Go ahead.
If you have land that was worth whatever $3 billion 6 years ago, that's worth more than $3 billion today.
Absolutely, absolutely,
Okay?
absolutely, absolutely.
And some of it is going to go down in mall space because the malls are going to shit. But some of that land is going to be worth more because of where it is and where it's going to be able to get developed upon. And so I'm just wondering, well, you'll get to it, but I'm just wondering when are they going to finally move on this?
That's what I'm on. I'm on it. I'm getting there. Yeah. Oh, so we know now all the stores have been closed. They call a LV, a net orderly liquidation. So we didn't sell stuff for 50 cents on the dollar, 20 cents on the dollar. We ran the stores in the ordinary course of business, sold all the inventory, and started working on either selling real estate or developing the real estate. So all of these properties, all this is publicly available. 1,100 pieces of real estate, average size 8 to 10 acres. Manoj and Art in San Diego, the UTC Mall, that land, that front part of that entire parking lot is owned by Sears. It used to be a Sears. It's been fully redeveloped, and they have expensive condos going up right now there, and that property is listed somewhere here. So I'm going to track these.
They redeveloped that land, but who owns it? Did they buy it now, or how did they redevelop it?
We own it. I think it's a joint venture, if I'm not mistaken. I think it's a joint venture. So I'm going to walk you through that in a second. I'm going to pull the real estate stuff up in 2 seconds. All of these are unencumbered real estate properties right here. All of these here. Now, what we're going to do now is I'm going to show you, everybody knows that we already have an agreement that explains what happens if the property is sold and what happens if it's credit bidded. It simply moves over to the new buyer, which was Transform, and when the stores are fully liquidated and or the IRS deadline, which I don't know the deadline. Normally the deadline is 3 to 5 years. During this time period, we had a pandemic. I believe that is why we have not been paid out yet, is because the pandemic extended the deadline. The IRS does not allow a liquidation of a subsidiary without payment of tax for more than a specific amount of time. We don't get to see when they extend it, but they don't allow it to go on and on and on forever. Usually it's 3 to 5 years.
So
February,
the IRS wants tax on the assets that are present, that are unencumbered. Is that correct?
Say it again, I didn't hear you.
So the IRS wants their tax, their piece of the pie of what is the unencumbered assets. Is that correct?
No. In this type of reorganization, the IRS does not get any taxes as long as the proceeds are distributed to us.
Okay.
There's no corporate, that's the purpose of doing it. So there's
what
no
does the
corporate
IRS get
tax.
to say? The IRS gets to say, you got to distribute it or we're going to tax it? Is that what it is?
Yes.
Okay.
Yes.
Got it.
So the
Understood.
reason I know we're getting paid is because the taxes would be more if he doesn't pay. So it's actually called a 368 tax reorganization. So you liquidate and there are no corporate taxes as long as you distribute the money to your creditors and your shareholders. So the math doesn't make sense not to do the distribution because
Understood.
the taxes, you understand? So the taxes on all of this money would exceed what we're owed as shareholders and what we're owed as bondholders. So there's no mathematical reason. So in bankruptcy, you have a lot of sharks, a lot of crooks, a lot of hedge fund guys who have no integrity and no morality. Eddie Lampert's not one of those. But even the immoral hedge fund guys, some of them, not all of them, they don't want to pay taxes they don't have to pay. They would rather pay their creditors instead of paying the IRS, as long as they comply. So
why would the taxes be higher?
it would be higher because they would be taxed on all of the money that came in from February 2019 to date, and they owe us a lot less than what the taxes would be. They would owe interest, penalties, and fees on more than $10 billion.
Okay.
So you do corporate tax on $10 billion plus interest, penalties, and fees. It's a lot more than a little bit of money we're owed on the bonds.
Okay.
Because the bond, okay. So
But
stay
not just
with
the
me.
bonds, though. This is also the shares of Sears.
That's right. That's right. But
Okay.
that's right. It shares of Sears too. But the actual debt, the pension is owed roughly $800 million. The remaining bonds are only owed $700 million. So everything after $1.5 billion goes to the shareholders free and clear.
Am I correct in saying that the longer they wait to do this, the more money they can make off the assets in the meantime?
Yes and no, because they can pay us out, issue a new stock, and they can continue the liquidation as long as they merge with a company that is still liquidating tax-free, or they get more permission, further permission from the IRS.
Yeah, no, I guess I should have phrased the question a different way. What advantage do they have to keep delaying a payout?
The advantage is there's no corporate taxes. That's why the IRS gives them a deadline. Yeah, because otherwise you could do it forever. So the IRS gives you a set deadline, and if you don't meet that deadline, they start charging you the taxes.
Got it. And so they're not paying taxes because they're in bankruptcy right now. Is that
No,
correct?
that's not. No, that's not it. They're
Then-
not paying. They're not paying taxes because they did a 368 tax reorganization that was approved by the IRS in February of 2019. So under that tax provision, the technical term is called the General Utilities Doctrine. It's a Supreme Court case that was codified into the tax law in 1954. Warren Buffett did it 3 or 4 times. J. Paul Getty did it. Other major players did it. They were abusing this particular process, to your point, Manoj. So from 1954 to 1986, there wasn't a deadline. They would just do it as long as they wanted. So the IRS repealed the law in 1986. So it's very difficult to do this kind of reorganization unless you're in bankruptcy, because they repealed the law that allowed you to do it in 86 because of so many people abusing it. So to your point, that's what happened.
Got it. So
Hi, Eric. Hi, Manoj. It's Mike Wax.
Right. Okay. So
I just want to say, I read about that.
Okay, go
Sorry,
ahead, Michael.
sorry to interrupt. It's Mike Wax. It's something I read about in my own research about that. Warren Buffett in 1954, blah, blah, blah. And he bought his first company, named Berkshire Hathaway. It was a textile mill. He didn't even know the tax net operating losses were there. Sorry to interrupt. Go ahead, gentlemen.
No problem. But you're right. So long story short, in a couple of seconds, what we're going to do is show where the property is now. And we're just going to look at real estate. I'm going to run the other numbers later, but I'm going to show you where the real estate is because the company gave an update less than a week ago. I'm going to show you where the same real estate is that was in bankruptcy, that was unencumbered. So we're going to pull up the Transformco properties presentation in a second when it gets ready. She was going to pull that up. But in the meantime, does anybody else have any questions while we're waiting on that? Anybody? Any questions? Blair, you see any hands? I can't see everybody. All right.
So far, good.
Okay. So here's the presentation. You can go to transformcoproperties.com and you can follow this real estate. Transformco.com, transformcoproperties.com, and you can follow the progress. If you take a look at the list that Adrian just scrolled, you'll see some of the same real estate being redeveloped. All right, so scroll a little bit and scroll to the first page. Here we go. The first page where it says 33 million. Here we go. So here's the property. 33 million square feet. It's 1.5 billion real estate under management. There's been 620 million in lease value created, and 1.7 billion of this real estate has been sold. So if we add 1.7 to 1.5 billion, we get roughly 3.2 billion. If we add 620 million to the lease, we have roughly 3.8 billion just from the real estate. Remember, we sold Innovel Solutions to Costco for $1 billion. We sold Die Hard to, I think it was AutoZone, for $200 million. We had 687 stores we liquidated with an average of $5 million in inventory per store. That's another $3 billion. Remember, the magic number is 1.5 billion. After 1.5 billion, shareholders are in the money. I just went over roughly $10 billion in sales and assets, not counting any income from Sears Home Services, the Shop Your Way credit card, Kenmore, which is doing amazing, or the online business of Sears and Kmart, which was doing roughly $2 billion a year with 30% margins. So if you turn the page, and all this is available online, it's publicly available. You turn the page, you see on page 4, next page is coming up. It says executed upon 3.7 million square feet of leasing. Completed over 1.7 billion in asset sales. Dedicated personnel teams include asset management, capital markets, equity placement, finance and accounting, facilities and management, construction and design. So when you turn the next page, you'll see some of the developments. You see this property in Sayville Plaza, Seville Plaza in Bohemia, New York. In March of 2021, Transformco leveraged its position in a substantially below market smart lease to purchase free interest of the Seville Plaza. Subsequently, the property was demolished and leased to a lineup of credit tenants including Aldi, Floor and Decor, At Home, Joanne, Taco Bell, and Chick-fil-A. In 2024, Transformco successfully financed and stabilized the site with a CMBS loan. You can see right below here, there's another 36 site they're doing a redevelopment of. 3,600 luxury multi-family units, 7 million square feet of commercial space, 60 plus industrial projects. Construction on the way and is delivery of first 272 unit building scheduled for 2025. That's happening right now. This is the same real estate that used to be old Sears and Kmart stores. Turn the page so we can see Pasadena, California. This is a great example here. In the next page, we're talking this project highlight right here. Hastings Ranch Plaza, Pasadena, California. Says since 1956, Transformco and its predecessors have ground leased a 15-acre site in Pasadena, California for a base rent of less than $200,000 a year. After discontinuing the retail operation, Transformco has generated substantial value by demising that former Sears building and subleasing to retailers, which brings in annual revenue of $4.6 million. So they turned $200,000 a year into $4.6 million a year with the same property that used to be a Kmart or a Sears.
But this is all property that is still part of the assets of the bankruptcy, no?
No, the February 2019, all of our assets left the bankruptcy in the sale. So we have not been in bankruptcy since February 2019.
Okay.
We have been, go ahead.
And so what, then how do, that's where I'm missing the link. How is it that these assets have left bankruptcy, but the shareholders from the bankruptcy have not been paid out on the assets?
Because the assets are subject to what's called a 360A tax reorganization.
Okay, gotcha. All right.
So it's a liquidation outside of bankruptcy to get us the most money possible.
So who is responsible? Which agency is responsible for the shareholders getting paid out from these assets during this 368 reorganization?
Well, there are trustees for each account. There's a trustee handling the unencumbered collateral account. There's a trustee handling the specified collateral account. And there is a trustee handling the stockholder account.
Okay.
And Eddie Lampert is the majority shareholder. So
Okay.
he's the one.
And who is the trustee handling the stockholder account?
I've been trying to figure that out. It's a bank, and we filed some requests to get that information, and we hope to have it within the next 2 weeks.
So there's been a trustee handling our stockholder account essentially since 2019.
Absolutely.
But they have no responsibility to tell us who the trustee is.
No, they told us in the legal documents. We just don't know who the person is. We know it's a bank. So we have to find out who the individual
okay.
is. Yeah.
Okay.
So right now, the mistake people have made, Manoj, is there is a wind down account in the bankruptcy. And it's a liquidating trust that they put $240 million in to wind down the remaining parts of Sears Holdings that were not bought out of bankruptcy. So people were calling them and they were like, we don't have any money for you shareholders. I think you guys got wiped out, because the people winding down Sears know nothing about the link between the assets leaving bankruptcy and going over to Transform, but still being owned by us. You understand? So most people think we're wiped out. They think, well, I didn't get paid. Somebody bought all the assets. I guess we're not getting paid. But the reason Eddie Lampert is putting these presentations public and talking about, quote, the other stakeholders is because we're the other stakeholders. So the Chapter 11 plan actually says that we get paid from the specified collateral and the unencumbered collateral. But people think the only money left is the small amount left in the wind down account because they're still operating the bankruptcy. But after February 2019, the $3.75 billion in unencumbered collateral left bankruptcy on the same day and went over to Transform to be redeveloped, sold, so on and so forth. So a new stock will be issued, or Eddie Lampert will merge with another public company of his choice, and then we will get issued stock in that company, and the bonds and the pension will be paid out that way.
And so okay, I guess what I want to know is, how do we have a guarantee? Who's guaranteeing that we are stakeholders that aren't wiped out, that we have a share? Who's watching out for us? Is it that trustee that we don't even know?
Yeah, we know. We just don't know who it is. It's listed in the documents. It's a bank. It's a. Let me show you. Adrian, I'm getting there. I'm getting there right now, Manoj. Adrian, pull up the chart, and I'll walk Manoj and everybody through this. So keep in mind, Manoj and everybody else, there is the Pension Benefit Guarantee Corporation. Is the pension. It's the government entity that oversees pensions. They're owed $800 million. They're owed $800 million, and they are equal to us. Our bonds are owed roughly $700 million, and the rest goes to the stock. So this is a chart that everybody's going to get a copy of that Adrian put together brilliantly, I might add. So she's listing all of the assets that Manoj is asking me about, and she's showing the 3 separate trusts and where the funds are. The people on this call and other people have been calling the trust in the middle. The trust in the middle does not have our assets. They do not have our cash. They don't have any of the assets I just went over. Those assets were bought and they're at Transform. The specified unsecured liquidating trust assets are over to the right in the green. And those assets were inventory, Kenmore, Craftsman by Sears, and what was the other? Kenmore, Craftsman, and Die Hard, which we know was sold. It was also, there was a lawsuit against Visa and MasterCard that all the retailers won. That's what the specified collateral cause of action was. It could be 50 million or so. If you go to the right in the dark blue square, the unencumbered real estate is in that trust. Innovel Solutions, the company we sold to Costco for $1 billion, that money is there. Sears Home Services, the #1 repair service company in the United States, and the #1 delivery. It was #1 for delivery of major appliances. That's what Innovel Solutions was. The Shop Your Way credit card was doing more than $300 million a year profit at the time of the bankruptcy. Profit. So it's more than $3 billion in that trust, more than $350 million cash, because you have to remember we have Kenmore's money is in there, but the inventory has to be a couple, $2 to $3 billion, because it was 687 stores, but I didn't count the inventory. I put a 0 just to show people how much money it is, not counting any of the money from the closing stores or the operating stores that went until the last store was officially closed, probably last week, maybe a week before. So this chart will be available. If you click on any of these things, it will take you directly to the actual document. And the last thing I'm going to say is the $1 million question is people don't understand that we still own these assets. I hope I have proven to everybody that our assets moved over to Transform via the court orders, and they're not in bankruptcy. They have not been in bankruptcy since February 2019, and that was subject to a court order that was approved in 2018. So Transform is holding our assets, selling, redeveloping real estate, and getting us the biggest return that they could do. Are there any questions?
Okay, we got that part. So I guess the question is, who's going to guarantee us that those assets, those shareholders, those will be made whole or paid out? Who, it's that trustee bank. is it possible as shareholders for us to, let's say, band together and file a lawsuit and say, we want to know who's paying us out or who's doing this or where our shares are?
No. The shares, if you look into your brokerage account, you don't have to sue anybody. If you look into your brokerage account, you'll see the number of shares that you're owed. Because the company has liquidated, Manoj, aren't any Sears holding shares anymore. They've already liquidated.
Right.
So you don't get a new share until the new company to shares. So we don't get to determine when that occurs, but there is a deadline. It's usually 3 to 5 years.
Right.
But because of the pandemic, it's been longer. As of February 2025, it'll be 6 years. But we did close the last store within the last 60 days, and that could be the catalyst because there are no more open stores, no more inventory to sell. That could be the catalyst. So it could be happening this year. Nobody hold me to the date because I don't know when it's going to happen, but it could be happening this coming year.
Right. And so the guarantors that we will get paid out, that we will not somehow get lost in the shuffle, if you will. I think you told me about another thing that happened with one of the other organizations where they tried to screw you on the money. The guarantor for that is this trustee. Is that correct?
No, it's not just the trustee. These people are bonded. And Eddie Lampert's money is in those same accounts. And so Cyrus and some of these other people. So there are other players whose money is there. The government of the United States, their money is there for the pension. It's $800 million. They're not going to let their $800 million not get paid because we're on par with them. We're equal to them. So I'm in touch with all of these parties. So we don't have to worry about. Go ahead.
Because we were listed as such in the original bankruptcy. Is that correct?
Yes. And all this stuff has already been approved by the court many years ago. And Lampert can't get his money without paying us. The IRS doesn't allow that. He can't just pull his money out and say, hey, I'm not going to pay these people. He's not that kind of person anyway, but that can't happen.
He can't get his money out because he's got the shares of Sears and they sold the assets off. Is that correct?
No, he does not have the shares. It's a little more complicated than that, but the IRS will not allow this to happen because the IRS has to get theirs. So that's the real key in there. That's what protects us more so than anything else. And the mathematical certainty is.
In what form is Eddie Lampert's money in this?
Because he would have to pay the taxes if it's not paid out. It's on him. He's the parent company. So he would owe the taxes if it's not paid out. He'd have to answer to the IRS.
He paid taxes on what these assets have earned and made. Is that correct?
Yes. He would owe billions of dollars in taxes if he were not to pay the money. And it's more than what he owes us. Much more.
Okay. So the corporate tax rate, you're basically saying they made $10 billion off these assets in the last 6 years, and they'd have to pay the corporate taxes on that. Is that correct?
Plus interest, penalties, and fees for probably 5 or 6 years.
Got it.
Can I ask a question real quick?
Yes, go ahead.
Thank you. Hey, Manoj, this is a very complicated case, man. So we all trying not to get fatigued. So would you mind holding the questions until the end, please?
Absolutely. Sorry about that.
Thank you, sir.
Yeah.
No problem. But we're gonna we'll cut the tape and we'll go Q&A right now, Blair. This is what everybody has been missing. Everybody online is pointing to the Chapter 11 plan and see, wiped out. See, it says you're not getting anything. Let me show why the Chapter 11 plan does not supersede Document 892 or Asset Purchase Agreement, which is actually the agreement that transfers our assets. Okay, I'm ready now. You recording, Blair?
Yeah, we're recording. You go right ahead.
Okay, so everybody, this is very, very important. I'm going to answer questions that White Coat Researcher, Elephant Analytics, Search for Value, Stephen Baker Law, and all the people online are misinforming you guys about. This is document 2507. This is the order, if I'm not mistaken, that confirms the plan. This is document 257 filed on February 8, 2019. Or it's the order, could be the order approving the asset purchase agreement. I think it is. It's document 257, page 71. all the talk online, is what the Chapter 11 plan says. What this document says, I'll read the highlighted portion. It's paragraph 53, page 71 of document 2507. Conflicts and precedent. In the event that there is a direct conflict between the terms of this sale order, the asset purchase agreement, and any documents executed in connection therewith, the provision contained in this sale order, the asset purchase agreement, and any documents executed in connection therewith shall govern in that order. Here's the key point, and this is why I don't pay attention to the Chapter 11 plan that says we don't think we have anything available for shareholders. It says nothing contained in any Chapter 11 plan hereafter confirmed in these Chapter 11 cases, any order confirming such plan, or in any other order of any type or kind entered in these Chapter 11 cases, including limitation, any order entered, any conversion of any or all of these Chapter 11 cases to a Chapter 7 under the Bankruptcy Code, or in any related proceeding shall alter, or any related proceeding shall alter, conflict with, or derogate from the provisions of the asset purchase agreement or the terms of this sale order. The sale order is what transferred the unencumbered assets and specified collateral over to Transform into trust to be paid to the shareholders of shareholders and unsecured creditors. There was also one more side, I think. There's one more, Adrian. Let me look while we're recording, Blair. There's one more. Let me see if it's up here. No, it's on the same page. Scroll down a little bit. This is paragraph 52. This is very important. I don't know how I forgot this, guys.
Eric, I can't scroll
Yes.
anymore. This is as much as I have.
I'm sorry. It's that top. I want to focus on paragraph 52, page. Can you blow that up so I can, for everybody, highlighted part at the very top? That's what we're going to focus on. Just pull it down. Yeah. There we go. This is very important because everybody keeps saying that the shareholders, which they call the equity interests, are not mentioned and they're going to be wiped out. Now, this is the sale order. So this is the order that is transferring the documents and the unencumbered collateral and the specified collateral over to Transform. So now they're going to tell you the binding effect of this sale order in paragraph 52. Let me read it. Y'all tell me if I'm crazy or not. Mind you, it's February 8th, 2019. This is months before the Chapter 11 plan. That the terms and provisions of the asset purchase agreement and this sale order shall be binding in all respects upon and shall inure to the benefit of the debtors, their estates and their creditors, non-debtor affiliates, any affected third parties, all holders of equity interests in the debtors. Let me say it again. All holders of equity interests in the debtors. I'm going to say it again. All holders of equity interests in the debtors. All holders of any claims, whether known or unknown, against the debtors. Any holders of claims against or on or any portion of the acquired assets owned by the debtors, including but not limited to all contract counterparties, leaseholders, government units, and any trustees, examiners, administrators, responsible officers, estate representatives, or similar entities for the debtors, if any, subsequently appointed in any of the debtors' Chapter 11 cases or upon a conversion to a Chapter 7 of the Bankruptcy Code. So even if they had converted this case to a 7, we were still going to get paid when they liquidated the company. But is it easier to liquidate a company outside of bankruptcy in the normal course of business, or is it easier to fire sale thousands of acres of real estate, billions of dollars in inventory, billions of dollars of businesses like Innovel Solution? You can't get a great deal on a house when you're in foreclosure. You cannot sell it at a great price. If you're about to get your car repossessed, you can't get a great deal on that car when you're in a hurry trying to sell it before it's repossessed. So Lampert took the company, moved these assets out, and he signed this court order was signed on February 2019. And he took those particular assets and moved them over and agreed to give us our money as long as the other debt was paid off. And we know that that debt was paid off. Do me one more favor, Adrian. Pull up document 2507. If you have it, do you have that in front of you, Adrian, or not? You don't have to do that. We're good. We're good. We're good. I just saw it. We're good. All right. Any questions about this particular document right here, or does everybody understand that the sale of the assets and the buyer of the assets who promised to pay us, not the Chapter 11 plan, not the actual quote bankruptcy, the buyer has guaranteed our payment. Is that clear to everybody?
Yes, yes.
All right. So there's no need to follow the bankruptcy. I've said this for 4 years. You follow transform.com and transform.com property. I think that's it, Blair. I can take questions. We can take the questions down. We can take it off recorded. We can keep it up. Let's take it down and just record the questions.